Welcome to this session, which is dedicated to the e-evidence or electronic evidence package. I guess many of you know quite a lot about this package, these two instruments. This panel has been our tradition for now. It's the fourth iteration of a panel on e-evidence at the CPDP, and we've been tracing the evolution of this package, of those instruments, from that moment. But actually, we on this panel have a record of examining the life of this topic since more or less it came into being as an issue in 2015, 2016, and then through the adoption of the respective instruments in Europe, but also of the Cloud Act in the US, which is extremely relevant. And then the proposal and the adoption in 2023 of the e-evidence package, and then in the recent years of how it evolves. And the idea for this panel was, okay, this year we have a panel just before everything comes into application. It will start applying on 18th of August. The regulation will start applying. And because it's a regulation, that's a fact. It will start applying because it's a regulation, doesn't need implementation, contrary to directives, but it requires a lot of national law, which I'm not sure if it's there. So when we designed this panel, so I designed it and we consulted on this, we thought, okay, we will have those national laws, maybe at least drafts, and let's discuss them. And let's see how they are. And that's the panel will be about that. But actually, it doesn't seem our panel will be on that. I think our panel will be, we don't have that national laws. So what's going to happen? Because the clock is ticking and we have only three months. So let me briefly introduce where we stand. 18th of August 2026, after 3 years from the moment of adoption, the e-evidence regulation is coming into application. Also, there is the directive about nominating the representatives, and this directive was supposed to be implemented by 18 February 2026. We will learn where we stand with this implementation, but I'm afraid it is not very advanced in the large majority of member states. From this moment, which is 18th of August 2026, we have this new system of acquiring data from service providers for law enforcement transnationally. So finally, and of course we had for many years huge debates, some are enthusiastic about it, some are less enthusiastic, some are more moderate, but we will have this system where an authority, being it a prosecutor or a judge in one member state, can ask a service provider active in the European Union, and the service provider has to provide an information where the order has to be sent, and once the service provider receives this order, in principle, in 10 days, the data should be sent to the authority. There are a few exceptions, we will get to that, but that's the system in principle. It's a huge revolution in how we acquire evidence in criminal procedure, because other instruments of criminal procedure require cooperation with another authority in another member state. And this aspect is eliminated. So contrary to, for example, the European investigation order, these instruments will offer a much easier, much smoother, much quicker way of getting evidence, data, for criminal investigation. The instrument is not about all sorts of data. It's about stored data. It's from certain service providers. We will come back also to that, which service providers. But as such, it covers already quite a lot and gives a very interesting possibility, and I think arguably something that will be increasingly used because it will be easier to use than other instruments that we know in criminal procedure, especially of international or European cooperation. But in order to to really start functioning and to come to being, we needed certain things to happen. And that's why the legislator, the European legislator, gave the European Union, the European Commission, and the member states 3 years to prepare. And those 3 years had to be used for 3 main things. First, prepare the national law, I'll come back to that. Second, for the Commission to prepare the technical infrastructure, what we call the decentralized IT system, through which data will be sent to the authorities which request it. And third, we wanted to give ourselves time to negotiate the agreement with the US under the Cloud Act. So at this point, we thought these 3 elements should be in place. The technical infrastructure, as far as I know, is already in the testing phase. We will learn about it more. Here I'm a bit less worried. But the agreement with the US doesn't seem to be in place. And of course, the negotiations are secret, but whenever I try to talk to somebody who seems to be engaged in those negotiations, of course, I get an answer, I cannot talk about it. It's not there, I cannot talk about it. But then I try to read the body language, and somehow I don't see sparks of optimism around. That's how I would read it. It's not coming anytime soon. So that's a problem, of course, because without this agreement, whenever we ask for content data to providers who are active in Europe but are US providers, they will be in conflict with US law. And that's going to be a huge problem because, of course, there are many US providers, and they are the major ones. And then there is national law. Several things we knew had to happen in national law because the regulation already said it. For example, the penalties had to be provided in national law. The remedies had to be provided in national law. But there are other issues that are maybe less directly addressed to member states, but they have to take care of that. For example, there is a whole issue of privileges and immunities. And the regulation has provisions on that, but leave what this means to member states. There are other issues, there are other problems in different laws that can come up. Conflicts with older telecommunications law, some sort of secrecy of telecommunication. There are problems of embedding the order in the criminal procedure. And there is, of course, the question which authorities are competent for different things, for issuing, for enforcing, for being notified, and how to react. These can be courts, this can be also prosecution services. Countries take very different approaches to that, but they have to decide. And my fear is, but this is anecdotal evidence from some engagement that I had, but I hope we will learn something more systematic, and then we can discuss it, is that the process of adopting national laws to the requirements of the regulation is still not yet as advanced as it should probably be 3 months before the moment that this regulation will start applying, which means that you will be able to use it. A judge will be able to use this order because it's directly applicable. But without this law, it can become very problematic. So the panel, we will talk about all those issues, about where we stand, about what we have and what is missing, and what it means that we have or not have certain elements that I just mapped out. And I think that's a good moment to turn to you, Tanya. You represent the European Commission, the DG Just. By the way, I will, as it's habit in other panels, I will not do a detailed presentation of our eminent speakers because you have their bios on the webpage. So for sake of time, I will not do that. So Tanya, maybe you can tell us more about this preparation of national law. You have an overview, and maybe also about this technical infrastructure.
Sure, thank you very much, Stanislas. So good afternoon, ladies and gentlemen. Stanislas already mentioned the evidence package is revolutionary from many aspects. It allows this cross-border direct requests to service providers. Data location is not a factor to be taken into account for that. And another quite innovative element of it is also how the directive works, because the directive is also transcends national borders. We've seen that when we discussed implementation with member states, and you actually have to transpose the directive by obliging service providers that offer services on your territory to establish a designated establishment or a legal representative, not on your territory, so not in your member state, but somewhere in the union. And if every member state does that, in the end, you will cover all the service providers, and everybody should then have be subject to one or several obligations and comply with them. And then enforcement is something where also a lot of coordination needs to take place. But so it works really as a European mechanism where every bit of the puzzle has to be complied with. Now, in the last 3 years, since we have the new rules adopted, a lot of things happened. There was a lot of preparatory activities. We had a lot of expert meetings to prepare, on the one hand, the IT system, the reference implementation, as it is called, and we didn't want to do that alone in the Commission, so we set up an expert group where we had representatives of member states and also of service providers, and we discussed, what should be the architecture, how should it work, what should be the workflows, what should be the features of the system. And then we also had meetings with member states experts to discuss the transposition, the legal aspects more. And we found out there's actually quite a lot of questions and of uncertainties about also how the transposition should work. Coming back to the IT system, there was an implementing act which was adopted in time a year ago in July of last year, which sets out the technical standards for the IT system, and so we thought everything is on track. And now we are 3 months before the entry into application of the regulation. The directive should have been transposed by February. We have so far received a number of transposition notifications, but it's still not half of the member states who have transposed the directive. Many are in the legislative process, so you have member states where this is in parliament and will be adopted soon, and you have others where this has not yet happened, so you have different stages of preparedness. And so we have now a lot of follow-up questions. We are busy at the moment to consider a bit what are the consequences of these delays, because there's a lot of legal and practical consequences of having several member states transposing in different time periods. So I can say a word about the IT system afterwards, but the first, we still have a few things that we need to do in the coming months. So we need to find a way for central authorities under the directive who are supposed to create a network and communicate with each other on issues like which service provider is covered by the evidence package. So this is something we are setting up at the moment. We will have a first meeting of central authorities on Friday to start discussing how do we want to work with each other. The Commission is also a part in that. We have a lot of questions about the scope. I think Georges will still also address some of these issues, because for some types of services it is quite clear that the evidence package applies, but then there are some more borderline cases where it's not super clear. Financial services are excluded, but in the crypto area, what is a financial service, what is not. You have new services who are emerging. There's also an issue with the directive, which provides an exception for providers who offer their services only in one member state, but a lot of telco companies offer services only in one member state because of the way they are historically established, but also to comply with national requirements. So telco providers, although they can be active in several countries, they usually do that through national subsidiaries. So does that mean that they are not covered by the evidence package? This is also an issue that we are still looking at and trying to solve. And then there are many other questions regarding the which companies are covered by the scope or are not covered. So this is, of course, also something where you cannot have one member state coming up with one interpretation and another member state with another one. You need to have a common understanding of how the directive applies. So there's a lot of coordination that will also need to take place on this question, even if in the end, many will be decided by the Court of Justice in a number of years, but until then we still have to function. There will be also some overview about cost reimbursement for service providers. That's just a detail that still needs to be published. And there's a lot of training going on at the moment. We provide some trainers on the IT system, but there will be a lot of training needs also for member states who need to train their practitioners on the new rules and on the IT system, and also for the service providers, of course, who need to also have an idea how this functions. So all this is ongoing. Now, with regards to the challenges that we're having because of the late implementation. So if you have no directive, the regulation is normally applicable because it's a regulation. Nevertheless, there is some things member states need to do. They need to, for example, nominate their authorities. There's an issuing authority or several issuing authorities that need to be nominated, but also an enforcing authority who should, in some cases, also be notified of the cross-border orders. Legislation transposing also or implementing the regulation is necessary, and then you have the legislation transposing the directive. Now, if you don't transpose the directive, there is no obligation for a service provider to nominate a designated establishment or a legal representative. And what does that mean? That means that also under the regulation, you have no addressee to whom you can address your European production order. So if a member state has not implemented the directive, you cannot address, in our reading, a European production order to a service provider who is established in that member state, because you don't have the addressee set up yet. So the regulation, even though it is directly applicable, it will be very difficult to make it apply if the directive is not applied at the same time. And the same thing is for the authorities, because you have often a parallel notification of the European production order to the service provider, and then also a notification to the enforcing authority in that same member state. If you don't have that authority, the system does not work. So you have a piece of the puzzle missing, which also means it works as a whole and will be difficult to apply it only partially without having both directive and regulation implemented in a member state for it to apply, being it for issuing or for receiving these orders. Now, there are also questions like what happens if one member state has transposed, the other one not, and the service provider is active in the two member states. Will it be fined then in the member state that has transposed, but it wants to establish its designated establishment in the other member state that has not transposed? That would be a very weird outcome. Huh? If somebody has transposed the directive, they also need to. We will have delays, so we will have some that will have the transposition legislation maybe still before August, but that does not necessarily solve all the problems, because if the directive enters into force, it doesn't mean that on the day after, the member state, the service providers will be registered in the system and will be connected to the IT system. So there needs to be some transition period there too for the service providers to do the necessary that the system can work. So we will expect some more delays. We also have we have a lot of discussion on question what happens if the IT system does not work. It seems the IT system is becoming a more and more crucial part of the system, because it ensures authenticity of requests, it ensures security of the transmission. And if the IT system is not there, okay, what does a service provider do? They will receive some maybe orders per email or per other ways, and what should they accept? Can they trust this is authenticated? So we're having a lot of questions. There is provisions in the regulation if the IT system is down that you can use any other, the most appropriate alternative means, but it's also it's going to be very difficult in practice if the IT system is not working. Maybe in the initial stages also there will be problems. So we're also reflecting and discussing with the experts what can happen in this interim period. So in conclusion, we will not have a big bang on 18th of August. I think that's pretty clear by now, where, hey, from tomorrow the e-evidence rules will be applicable. It will rather be a gradual process where you will have member states and service providers joining progressively, which, okay, in the end, maybe in a year we will sit here and say, oh, it was a good thing because it allowed us to solve this problem and that problem. And in the end, it's easier to do that when you have a smaller group of participants than a bigger one. We still have a lot of work, but looking forward to next year. So.
Yeah, sure. Thank you very much for letting us having this panel for many years to come. Thank you very much. That's very insightful. I wouldn't say reassuring, but that gives us some understanding where we stand. It's interesting what you said. No big bang from August. I still expect some small bangs, especially when creative lawyers come into play. But I will come back to this thought. But maybe let's turn to Vanessa and let's try to bring this down to a level to member states more concretely. Yeah? You are active in Belgium. You have some insights into how this works, and you've been studying this field also through comparative studies for many years. So please, the floor is yours.
Thank you very much. Indeed, my own member state was in 2016 one of the member states pushing for the e-evidence package, and the Minister of Justice back then put forward a proposal that actually mirrored very much what eventually was in the e-evidence proposal of the Commission: direct cooperation, cross-border cooperation between a member state authority and a service provider. That's already the Belgian model. It has been for over a decade, but it's purely based on national law with all the problems and questions that brings. How can you enforce a production order against a service provider that has no establishment in your country but is only offering services? But we've had a number of creative prosecutors and judges who have pushed forward the case law first, and then that case law was codified in the Belgian Code of Criminal Procedure. So you would expect that member state, who was one of the member states pushing the European Commission, to be among the first ones to have everything in place because they were asking for it. What is our finding? Probably Belgium will not have a legislation before the fall. That is surprising. That is really surprising. I've understood that there have been a number of human resource problems at the level of drafting legislation within the Ministry of Justice. That's how it works in Belgium, at least. We have no codification commissions, for instance. There's no academics involved. Punctually, they might be on a confidential basis involved, as I have been, but there's no structural process. In Belgium, we have the Ministry of Justice, who prepares legislation for the government with the different stakeholders, and those stakeholders are judges and public prosecutors. The police probably also, but I guess it's more the prosecutors and judges that were involved. Based on what I've seen, what I've seen from a draft bill, but it's still not final. To come back to what Stanislav said, how will this instrument be embedded in national law? I see a horrible piece of legislation because it's not just amending the Code of Criminal Procedure. And again, my member state already has cross-border production orders in place. It already is based on the criteria, if you're offering services within the Belgian territory, then you can be addressed without going through a legal representative, as is provided by the directive. But that's already how the system has been functioning, and quite well. Quite well, because if you don't comply, it's a criminal offense. So if, as a service provider, you don't comply, you can become yourself the suspect of a new criminal investigation against you. But what I've seen is that there will be several pieces of legislation amended, and for instance, part of the production orders would be in the Code of Criminal Procedure, but defining which authorities are competent will be in a different piece of legislation. There's also there would be amendments to the legislation that applies to the competent authority, which would be the Belgian Telecom and Postal Institute, which is also the authority for the DSA, that has been designated for the DSA. And it would also be that authority that would be responsible for taking measures against non-complying service providers that could also impose administrative penalties. So that's the layout. I think the way the law is being drafted is extremely complicated, because it refers very often to the regulation, which makes sense, of course. But it refers, for instance, to Article 5, to different points, to the points 5.4a and b. You have different authorities that are competent. Sometimes it says that you need a judge, and otherwise for the same data, but for different offenses, it says you need a public prosecutor, but then you need the authorization of the judge. What's the difference? What's the difference? In my own system, it doesn't. I mean, if an article says you need a judge to order this production order, it means that the judge can be asked by the public prosecutor. And nonetheless, in what I saw, there's distinctions that are made that are new, which is interesting. What I haven't seen so far, and perhaps that's reassuring, that so far there's no indication that national law is going beyond the scope of the regulation, saying it's not clarifying, for instance, what data that are purely for identification purposes requested. We just refer to the regulation, which is reassuring, because then you don't get interpretation problems. That's reassuring. So there's a number of positive things. I also see, at least I have the impression that penalties, administrative ones, can be very high. I saw figures up to 1 million. So not complying with a production order would be a fine of €1 million, whereas the criminal penalty that is in place is 30,000 euros. So there's a big difference. Well, that's 30,000 multiplied by 8, now 10, so it's still considerable, but the administrative fines seem to be much higher. I didn't see any rule on how will administrative and criminal enforcement be articulated. In which case will the case of non-compliance of a service provider be handled by the prosecutor? Will it be a new investigation and possibly lead to a criminal conviction? And in which case will it just be handled administratively? Which raises the question of ne bis in idem. How will authorities coordinate in enforcing? I know that there has been a reflection process, at least on the part of certain stakeholders, on how will this new regulation and the law as we are drafting it, how will it interact with the future implementation of the second additional protocol? Because we also have that now. So it would have been nice to reflect in a structural way and say, how are we going to draft the law, the national law, now that we have finally an international and European legal framework for cross-border orders? And what we see is that that effort cannot be made for undoubtedly limitations in time and human resources. But it would have been a very good reflection, of course, not just to say, okay, we're gonna make sure that the regulation, that we have everything in place. And so that's a missed opportunity. I don't know if there's other member states who are more proactive and reflect on how are we going to redesign our law to already create a space for the other production or preservation orders that are coming with third countries and not EU member states. So what will happen, and this is a real concern, I mean, it's a real concern that has been expressed by public prosecutors in my own country. What will happen on the 18th of August if we don't have the legal framework in place? I heard from an Italian colleague that Italian judges are already now sending questions to the Court of Justice, apparently, as they want to interpret national law in light of the regulation before it even is applicable. I think that's very interesting. But on the 18th of August, the regulation will become applicable. And it's, of course, directly applicable, but it requires, it's a bit of regulation, it's a bit of directive in disguise, as we've seen others, because you need national law to make it function, as Tanja already said. So I don't know what will happen. I think my own member state will just continue to do as it has done for over a decade with its own national legislation. I don't think you can issue an order if you don't have a designated authority for the notifications, if you don't have any enforcement system in place. I mean, we have something, but it's not based on the regulation and it's not fully compliant with what is laid out in the regulation. So, yeah, there's big concerns, and I know that some stakeholders are pushing the government to have the legislation that is needed in place by the deadline, but it doesn't seem to be realistic for whatever reason that may be. And so that's surprising. And I think there will be many, many questions. If it's a gap of a few months, probably we will be able to bridge it as we have data retention legislation in place. For instance, so not all the data will be gone, as they need to be retained for a certain period of time. But nonetheless, it will be a very tricky, very, very tricky situation. I think I will leave it.
Mm-hmm. Thank you very much, Vanessa. You made a number of very, very important points. I think what's very interesting that you underline also this reflection on national law beyond the regulation. Like, so the question how the regulation impacts national law, not where it demands changes, but where it affects the national system of getting data from national providers. And the reflection also that countries, that member states have to make is, if we have this system according to the regulation for getting data cross-border, what do we do with our provisions that remain in place, which allow us to get data from the local providers? Because there is fairness, there is equality. Can we have them completely different according to different thresholds? Maybe we can, but is it the optimal solution? And I think many countries are having this reflection and have to have this reflection. And that could be an interesting impact of this regulation and of European legislation as such. I'm also, another point that I wanted to pick up, and that's where I stop, it's when you said it's a directive in disguise. But I think member states have to be very cautious not to try to implement it by copy-pasting And I cannot say much because it's a secret process in which I was somewhere engaged in a certain member state, but I saw this kind of instinct because people who are doing this in ministries of justice are often the same people that are used to implementing directives because they've been doing it for many instruments. So they have this instinct, okay, we have to put it somehow in national law. No, you don't. You don't. And if you start doing, you can create a lot of mess because then you will have two texts directly applicable on the same thing, and that can be very, very dangerous. So I think there is a lot of, it's a minefield a little bit, this quasi-implementation. But let's change now the perspective. I turn now to Ryan from Microsoft. Let's look at how this moment looks from the perspective of a service provider, especially a big provider that provides services in all member states. How do you see this from your perspective, knowing that in theory, I mean, you have to be ready for 18th of August, that this law is still a shaking ground, and how do you see also the technical infrastructure that it's about to be offered? The floor is yours.
Thank you so much. Thanks very much, and thanks very much for the opportunity to talk about this. I first encountered the evidence regulation from a very different lens. I was a prosecutor in the United States for years, working on cross-border data issues in negotiations from the US government perspective, and running a lot of investigations that would run into cross-border data issues when we were trying to seek evidence. And so I've seen this, I think, from a few different angles. Entering it now as a service provider lawyer is, I think you're right to point out, it's particularly challenging because we have a clear deadline, but also not much clarity yet on what happens on that deadline. I do, though, want to take I think you started a bit with it. I want to emphasize the revolutionary nature of this instrument. I think it is easy when you're at this stage of implementation to get caught in the weeds and get focused on the challenges, and there really are challenges. We will all have jobs for a while, I think. But it is also transformative. It is a seismic shift in the way that law enforcement approach situations where data they need is in another member state, another country. I mean, it's the first multinational instrument to come into effect like this, and the second additional protocol, which will shortly follow, is another, I think, really amazing accomplishment by governments. These are extremely sensitive spaces at the core of government sovereignty, law enforcement issues, and for governments to come together and agree amongst themselves on a core set of safeguards, on the appropriate principles for access to their citizens' data so that there can be timely issuance of orders across borders, so that everybody can move at the speed that the criminals are moving. I think this really, we have to remember that this is ultimately an incredible project. But at this particular moment, we do have a lot of things to focus on. So I'm going to talk a little bit about how Microsoft will approach it. And I think one of the hardest things here is that no service provider is in exactly the same position. So each of us are probably having to do lots of very specific legal analysis for the way that we manage our EU services. In Microsoft, we are established in Ireland. We consider ourselves an Irish company for the purposes of Europe. And so we currently respond to Irish requests for data relating to our EU services. This regulation will access that data through European production orders. So it will massively ease our burden as a company. It will make it cleaner and easier for us to explain to our customers in Europe what the requirements are, how we're protecting their data, and what kinds of safeguards are in place should there be some kind of public safety need to access it. Really wonderful things. We do, however, need to be able to register. So transpositions need to be done in order for us to take those steps. And then we need to know that the orders we're receiving are valid and on firm footing, because we ultimately have a responsibility to our customers to make sure that we are compliant with the laws and clear with them about what is essentially their personal information. So we have the kind of legal questions that are still outstanding. We have an IT system, which is another, I think, not to be undervalued incredible effort. The IT system as proposed is going to be the first multinational IT system for these kinds of things. That's a massive change. They're huge. It's a very ambitious project. Ambition is a good thing. In this moment, it's going to be a little challenging because it's not clear that everybody's timelines are on the same levels, as has been pointed out. We do have this space for if the IT system isn't fully up and running, there is kind of this alternative mechanism in place. And that's where Microsoft is in a bit of a better position because we have an existing law enforcement portal. So we have an existing structure that we use to verify law enforcement requests, to receive them securely, to respond securely. We will expect to use that system until the IT systems are available and ready, because we know that that will meet the requirements in the regulation. It will be secure, it will be reliable, and it will let us do the validations we need that the person asking for the data is in fact law enforcement. Many people here probably know criminals also like to pretend to be law enforcement. So we have a pretty significant part of our job is making sure that the requests we get are really from law enforcement, and our portal is our best way to do that until the IT system is working for everybody. If the laws are not all done and ready, the current approach that Microsoft takes in Europe is this process of, I often hear people describe it as voluntary disclosure. We have a limited set of data that we disclose in response to domestic orders, but the emphasis there is limited. So some kind of basic identifying information about the person who might be holding the account, where we get a valid request under the domestic law. We will keep that going. The idea of e-evidence is very much to level up. We're not going to look at August 18th as a moment where our voluntary system closes down just because there's officially a regulation on the books if the actual underlying laws are not ready. So we're waiting for the laws to be ready, and that will be, it seems, member state specific, which will make my job quite interesting for the next year or so. But once the laws are on the books, we will expect people to use the European protection orders, because at that point, everybody has done the necessary to make the legal obligation that the entire EU has agreed upon, and it would not be appropriate for a service provider to second guess the standards and the frameworks and the safeguards that member states have agreed together. The whole reason why Microsoft likes these kinds of frameworks is because we want governments to get together and set those rules. That's the purpose of governments. We don't want to be in the business of making those kinds of decisions. We will always have our emergency process open. We respond to emergencies right now. We have someone look at it within 20 minutes and we respond within 2 or 3 hours. That will always run all around the world. That's never going to stop. Emergencies supersede anything else. But we will eventually expect all the participating member states to move over to that European protection order. And those protection orders will access content for EU services. So it will be a significant change in the capabilities of European law enforcement. As you said, within 10 days, European law enforcement will be able to get content data relating to EU services. Having seen it from the other side as a prosecutor, that can make or break a case. So it will have a genuine positive effect on public safety. And there will remain a gap because our global services will not be covered within that scope. And we'll, I think, get to see it in practice as things extend, but there will be a certain set of services that are relevant to a European investigation that are not within the bounds and will require mutual legal assistance requests in the way that it works now. The way to address that would, of course, be an agreement between the US and the EU, in the same way that the US has an agreement with both the United Kingdom and with Australia. And what I imagine everyone here is well versed in those agreements, but essentially what they are is another agreement between governments on a core set of safeguards so that there can be this quick access to the other country's providers within a set of defined parameters. I very much hope that there will be progress on those agreements. I'm excited about the second additional protocol. I think that's another space where we will see this kind of test of theory that governments can, in fact, make these decisions at a government level and help us have modern law enforcement that can respond to modern crime. I hope very much that we will continue to have more data access frameworks like this. I think the e-evidence implementation process is very close to my heart in some sense because this is the first test of a theory that has long been discussed. And if we can make it work and work well, the goal would be that this would kind of keep growing around the world and help companies have more clarity about our responsibilities, let us tell our customers what we will and won't do for their data, and let governments fulfill their core function of public safety.
Thanks a lot. This is you made a lot of points that I would ask many questions now, but I would stop myself. And thank you also for underlining the second protocol. I omitted it from the panel because we only get one slot at this big and beautiful conference. But of course, that merits maybe another panel and maybe in the future because it's still a slow process of ratification. But at one point, it will become very relevant, as you say. So probably we will come back to this discussion. So before I jump into questions, I turn to George. Who represents here the defense perspective. Also, you represent the European Criminal Bar Association, and let's hear the points how it looks from your side. What do you see in the regulation? What issues you see in the regulation? The floor is yours.
Yeah, thanks, Stanislav. Well, I'm a lawyer, so it's going to be a little bit of a lawyerish perspective. Basically, I want to share with you some thoughts about what service provider fall under the regulation, and if we could discuss about some controversies regarding content data and encryption. Okay, so regarding the first topic, which service provider fall under the regulation, I think the banner there is very interesting because you have the sponsors section, and if you remove all the law firms, you already have a lot of relevant examples there. But basically, if we look at Article 3, Paragraph 3 from the regulation, we can see that we first have the electronic communication services, and here we can talk about webmail, we can talk about email services, OTT messaging services like WhatsApp, Telegram, Signal, etc. Telecom operators, which is obvious, VPN service providers, which is extremely relevant. Then we have the DNS and IP numbering services, and here we can talk about GoDaddy, Namecheap, and you name it. And finally, I think one of the most important categories here is the information society services. And here we can talk about cloud storage, we can talk about collaboration platforms, for example, Slack or Discord. We can talk about social media platforms, we can talk about marketplaces or even hosting platforms like GitHub, you can see it there at the sponsors section, or even WordPress.com. But I think that and these are basically obvious examples that fall under the regulation. But talking about a possible controversy regarding the service providers, I think that we should look at this criterion named significant numbers of users that the regulation is talking about, specified under Article 3, Paragraph 4, letter B. Because we don't actually have a threshold for what significant number actually is. And the relevant question here is what does significant means when we are talking about a small service provider, for example. And there is also the issue of sock puppet accounts or bot accounts that can be created. They are fake accounts, but basically create the opportunity to place a service provider under the regulation if it's not an EU service and doesn't actually provide services for European citizens. It just have fake accounts that seems to be created from the European Union. And this is an interesting example, I think. And I will also like to emphasize that it is pretty much unclear whether some service provider actually fall under the regulation. And a relevant example in this context is the LLM as a service, because it obviously extremely important to talk about LLM as a service, because nowadays artificial intelligence is the new rage, right? Everyone is talking about artificial intelligence. And if the perpetrators are using artificial intelligence, obviously authorities need to collect data from an LLM service provider, because we can have relevant prompts, we can have relevant outputs generated by using LLM services. Okay, maybe the perpetrator is using the system to create phishing emails, maybe he's planning his modus operandi. So the data can be extremely relevant for the authorities. And I would argue in this context that these services fall under the information society services. They are not interpersonal communication services under the European Electronic Communication Code, because basically the definition from the directive requires a direct interpersonal and interactive exchange of information between end users. And when we are talking about LLM, basically we are talking about a communication between a user and an artificial intelligence model. There is no communication between two end users, okay? So it is important to understand that from a technical point of view, we can talk about an LLM service provider that has basically a persistent server-side storage of data. But we can also talk about LLM service providers that offers what is called a secret or a incognito or a temporary chat. And regarding these examples, it's interesting to understand that these types of conversation basically are not visible in the session history, but they can still be retained for a specific amount of time by the service provider. So what is the possible controversy here? Well, if we are taking into consideration this category of information society service, it can fall under the regulation if we can talk about essential, if we can talk about the storage data as being essential component of the service provided to the user. So it must be essential. So the relevant question here is if the data is not actually persistent, but it's temporary, can we talk about storage as being the essential component of the service provided by the user or not? And if the temporary buffering is sufficient to talk about the service provider that falls under the regulation, basically that service provider needs to have a system able of making the data available at the moment it receives a production order. And in my view, in such a context, such a mechanism is much closer from a nature point of view with interception than actually production of stored evidence. And we also have the case of centralized exchanges, Binance, Kraken, Coinbase, etc. These exchanges classified as a CASP under the MiCA regulation have custody over the user assets and have a lot of interesting information for an investigation body. It has KYC records, it has IP logs, it has device fingerprints, it has off-chain transaction records, and so on. So for criminal proceedings involving crypto assets, centralized exchanges play a major role. But what is the controversy here? Well, when we are talking about which service providers fall under the regulation, we need to exclude financial services. So the question here is whether crypto trading accounts to a financial services or not. And from my point of view, the answer to this question is no. The problem is that sometimes some CASPs have a mixed nature. Some of them are purely crypto-only platforms. They don't have a banking license, they don't have a fiat infrastructure, so these entities are not financial services. But others have hybrid licenses. They can have a payment institution, they can have an electronic money license, and so on. And I think in this context, the most relevant example is Revolut, because Revolut has a banking license, it has an e-money license, it has stocks, ETFs, all of these are financial services, but is also a CASP according to MiCA. And it also has a chat that allows the users to talk to each other, which can basically place Revolut in the category of electronic communication services. So it's interesting to find out if you need more than one order in order to gather all this data, or one order is sufficient. And the last topic concerns the content data, the storage data, and the issue of encryption. And here we need to make a distinction between end-to-end encryption and server-side encryption, because obviously when we are talking about end-to-end encryption, the service provider doesn't actually have the decryption key in order to decrypt the data. But if we are talking about server-side encryption, and the most relevant example here is the Telegram cloud chat, basically everything that is not secret chat, okay? Because when we are talking about secret chat, we are talking about end-to-end encryption. But otherwise, basically Telegram has access to the decryption key on their servers. So it can actually decrypt the data. So even if we have the recital 20 from the regulation that basically states that the data must be produced whether encrypted or not, and the production order doesn't impose a decryption duty for the service provider. The possible controversy here is the following. Obviously, when we are talking about end-to-end encryption, there is no decryption duty. But what about server-side decryption? Because the service provider, as I told you before, has the decryption key. So the question here is, what should the service provider offer as data when it receives a production order? The ciphertext plus the decryption key, or the decrypted content? That's the question. Because under the regulation, it's extremely easy to argue that even if there is no decryption duty, that duty may be relevant when we are talking about a production order regarding the communication of the decryption key. And in this case, I think that the Podchasov versus Russia case is not applicable, because in that case, the issue was to compel providers to weaken the end-to-end encryption for all users. And server-side encryption is a lot different. That's it. Thank you.
Thank you. Thank you very much. Yeah, a lot of questions. I think we will see also a lot of litigation about that. And I think it's also very interesting point about the LLMs. A classic of criminal procedure. The perpetrator, especially if it's not a professional criminal, soon after a murder, Googles how to get rid of the body, how to dissolve a body in acid, and then you have this in the Google history search. So somehow you'd think it's a basic mistake to do it, but people do it apparently. So yeah, a lot of questions. I have plenty, but we don't have plenty of time. So I will immediately open the floor for questions, and I already see Theodore.
Well, first, thank you for a really extremely interesting panel, and all the panelists were really fascinating. The only problem is that I was coming here for answers, and you were just asking questions. And I will add a few. I just wanted to start with the great points raised by George, and say that the 2nd of June, I will publish the second part of my study about access to interactions with chatbots, and this entirely confirms that law enforcement and intelligence agencies are already making a lot of requests to, and they have started publishing transparency reports, OpenAI, etc. And by the way, not only for users, specific users, but even though we have the first reverse prompts which were served to OpenAI, which means who asked this? Which is something which could go a very, very long way. So I don't see how this providers, and especially you have, for instance, Google for Gemini. Google is already covered, so why OpenAI will be excluded for, it will fall under e-evidence, that there will be a huge interest. But let me ask, Tanya was so diplomatic and soft with the member state countries, did not even say that the Commission started infringement procedures against 22 states who have not implemented the directive. And I wanted to ask you, for an answer this time, what explains this extraordinary delay in transposing the e-evidence directive? Is it the usual latency of EU member states on these issues? Is it discomfort with a novel architecture? Is it lack of administrative and technical capacity to deal with it? Or is it just that they want, as Vanessa said, keep on using the usual national mechanism that they wanted to use and they might want to use also simultaneously? And this makes me also ask a question for Rian about the service providers. I could ask you a lot of questions, but I will limit myself. First, do you feel confident as a company working so much on cybersecurity every day? Do you feel confident about the cybersecurity of the exchange platform? This is the first part of the question, which has been created by the Commission, if I understand well, by IT experts of the Commission. This is the first question. The second, imagine that all these things are put in place finally. The 18th of September, all EU member states moved during the summer, as they always move very quickly during the summer in Europe, to put everything in place. Are you going to decline if Belgium, for instance, instead of using the e-evidence, they use their national mechanism? Are you going to respond to them, no, we will not answer to you unless if you use the e-evidence mechanism? Have you taken such a decision as a service provider? And the final question is, we know that the European Protection Order can only be addressed to you if you're acting as a data controller, normally, unless for the exception if in the interest of the investigation. So are you going to respond to member states? No, we will not respond to this because we're a data processor and we're handling, and you have not justified enough that the exception is present. I want your insight on this. Thanks.
Who gets to go first?
I give you time to reflect.
So who go first, Tanya? Yeah.
So good question. I'm wondering exactly the same. But to say the truth, normally, a recent example of another, not super recent, but the European Investigation Order was, I think, adopted to 2014 and had to be implemented 2016 by the dates when it had to, start being working and had to be transposed. We had a handful of member states, I think, and it took 3 years for everybody to be on board. So member states work slowly. The 3 years timing that was foreseen in the regulation and in the directive were short, given also that the IT system was added. So that's an additional difficulty for member states who struggle with resources. And then I don't think that complexity of the instruments helps, of course. But yeah, it does for sure not express any unwillingness to get on board with the new instruments. Everybody is still, very much looking forward and thinks it's going to be a game changer for criminal investigations.
And now I have 3, right? Okay. Just making sure I kept track. 3 is good. Okay. So on cybersecurity, we are, I think, privileged to have the opportunity to support the expert group for the IT system. And so we've been quite active in working with the Commission on the development of the system, and will continue to be active over the summer on testing. And then we will also, I think, take advantage of testing opportunities where offered in the member state where we will designate a representative. We are doing all of that, and as involved as we are, because cybersecurity is so critical to our company, and because ultimately what is moving through these systems is the data of our customers. So we are taking every step we can to make sure that it is as secure as possible. And I think this has been a good collaborative conversation. We have a number of engineers in the room and security experts in the room able to represent what we would need to feel comfortable with the system. And there's still, I think, a good summer full of testing to go. So on that one, I do feel like our concerns are being heard. I know I think each member state is approaching their connection process a little bit differently. So we will also likely have more to track over implementation. But I appreciate the open lines of communication we've had on that one in particular. I think that's one where our company's interest in security and everyone's interest in security in this particular space is really positive, but it will be really top of mind for us to make sure that that is met. The second one was about domestic versus European production orders. So we're established in Ireland, and right now we are voluntarily disclosing data from our Irish entity in response to domestic orders. The European production order is the EU's proposal for how to handle a cross-border data request. We don't think it's a company's responsibility or place to question what the EU has set up. So once it comes into effect, if there's a member state that's seeking data from our Irish entity, we would expect that they would be using the framework that they all agreed to use for those kinds of cross-border requests. And I think we'll have a transition process there too. As with all things, the important part is balancing the practical with the new system. Change can be quite challenging, but it's usually for good reasons. So we'll help people get there. And the data controller question, we were, as you know, quite active in pushing for the data controller versus processor distinction that you see in the final regulation. We're very happy that it's there. And we will be, I think, in conversation with law enforcement to make sure that any request that comes to us where maybe they didn't know that we were a processor and not a controller, we'll make sure that they're aware and that there's a different process for that under the regulation. If there's a situation where an exception they believe applies, we'll be in conversation with law enforcement to make sure that everybody is understanding how that's being applied. But we have an obligation to our customers to make sure that people are going to them first. And for those who are not kind of deep in the weeds on the controller versus processor piece, this is essentially our company clients where it makes best sense for everybody to go directly to the company. They are the controller of the data and also are in a much better place to provide the data. So I think we want to make sure that everybody knows that. In my experience, that's not a distinction that law enforcement's always tracking in their investigations. So it is usually best handled by conversations we can talk people through.
But with the forms that they have to use, we force them to, look at this and say, yeah, this company is the data controller. And it should also mean, maybe it will be information that companies will provide. We've also foreseen that in the registration form that they can give this information. I'm controller for this kind of data or for this kind of service for this data and not for another kind. So that could be helpful.
There was one question to George, or it was just a comment? A comment.
Just
So if we can try to pick maybe two more questions. If there are more questions, just please make them short so that we have a chance for answer, because it's very strict here and they will
It will be
switch us
much shorter. It's just a follow-up question for you. So just if there is an investigation on a certain company whose data is hosted by, let's say, Microsoft as a processor, the judge cannot go to the data controller because they are investigating on them. So, practically, I think they will go to the data processor. I'm just wondering how is this covered in the regulation?
Let's take the other one and then.
I'd also like to ask Ran if you're preparing in any way for those grounds of refusal because of immunities and privileges, or do you just think it won't ever happen because you can base it solely on the production order and Yeah, do you prepare for this, or do you think it will just never happen because it's like a super weak provision with regard to fundamental rights protection?
So we have two questions for you. Maybe Tanya, you want to?
I might let Tanya speak to what the regulation does on the if you can't go to the controller because they're the target of the investigation, because that kind of speaks to the.
Yeah, so that means you have to use other tools and not a European production order, because you have to, European production order, you cannot go beyond the scope, which is the services defined in the regulation. Okay, but then you can use European investigation order, MLA, depending on the situation.
And there's a little box. The form has a checkbox for if the investigation might be compromised by notification or going to the controller. And so they're coming to us instead. And that's the piece where we're going to probably have some conversations, because we want to make sure that we are all on the same page of who the actual controller is. We have our internal records of a controller. Law enforcement will tell us we can't go to the controller because it would jeopardize the investigation. We will probably go back and make sure that we both understand who that controller is, so that they're making that determination with the best information available to them. But it's a recognized exemption that sometimes a company might be the target.
It's the Volkswagen clause, we call it. At the time, was very relevant.
And on the immunities and privileges question, so the enforcing authority will have a responsibility to look into that piece of it, but we don't consider ourselves wholly out of that space. We care, again, our primary responsibility is to our customers, and so where there is on the face of an order a concern, certainly we will raise it with the enforcing authority. That's the appropriate mechanism. I think the challenge for service providers is the way that the European production order contemplates us receiving the information is we actually do not get very many facts about the case. And so if it's not clear on the face of the order who the target is, what the situation is, we don't have as much information to move on. But that's where the enforcing authorities will have a lot more.
Yeah, we have time still for questions.
Try to be quick. Hi, I'm Filippa Motto from Uber, and I have a question just to pick when you said now, Rian, we are not going to get a lot of information, and we used to get it, at least at Uber, in voluntary disclosure, law enforcement tells us who is a suspect, if there is a safety risk, and because we are a car sharing platform, for us it's very important for our users to know if we can keep or not a person in the platform. So my question is, are there any strategies to the future to overcome this? Is there going to be any responsibility of the authorities to let us know if we should keep a user or not in our platform? Because for us, it's going to be a sensitive topic, because now we have an open line with normally the police and prosecutors as well, but they tell us on voluntary disclosure, and now they don't need to tell us who is a suspect, what is the type of crime, and so on. So that's my question, because it's going to affect because we are going to be blind in these subjects. So I'm just curious if in the future, or if this was being thought about.
Yeah. Maybe Tanya, you want to pick up on that?
Yeah,
I'm not sure who's.
So what difference does it make for you if it's a suspect or not? What?
So I think she's asking about whether or not whether it would also be a terms of service violation that would mean that the company should no longer offer the service in the future. So like in their case, if it's someone who committed a crime in the car,
Exactly.
they would not let them use a car again.
Yes. For example, if you have a partner driver that I don't know, murdered someone, or if he's suspect of rape, and in the meantime is between the trial and so on, it can still be in the Uber, providing services. And now we get this information, but with this legislation we won't get this info. So for us is a worry, because we want to keep our platform safe. So it was just food for thought. Maybe if there is no answer, but for us will be important, because again, we are a platform that puts people together in the same space. So we are always pushing for safety.
Yeah.
couldn't you blacklist that user on the basis of your terms and conditions? But you're rather referring to you don't know who the suspect is.
Yeah, if
But
the,
that's part of, I mean, that's,
No,
yeah,
it's confidential.
No, I think
information.
it's an investigation, and there's also the presumption of innocence, so it's a bit tricky, of course.
but there is no mechanism also after the trial to be informed or not about the result.
I very much understand. So I think the problem here is that right now there's an informal communication that happens. So as a service provider, people come to us for evidence for a variety of reasons. And sometimes that evidence is because the criminal emailed a totally unrelated person and they know that, right? And so the target identifier might not actually be a suspect of the crime. And what you're getting right now is an indication of whether they are the suspect of the crime. And the epochs will not have that indication. There is a mechanism in the contemplated IT system for kind of requests for additional information informally. So there's opportunity, I think, for us to continue our conversations with law enforcement. But I do think we're going to run into this problem where law enforcement feel kind of your initial reactions. You don't need to know that information. But from a company perspective, if there's a potential terms of service violation, that's a much lower threshold than a criminal conviction, and you would want to know whether you ought to be placing it in that space.
Yeah.
Thank you.
Thank you. Maybe a very quick question from me to you, Ryan. Do you feel uncomfortable that there is no agreement with the US coming August, or not?
I don't think uncomfortable is the right word, because I think it's a missed opportunity that the two are not coming online together. It would be better, I think, for public safety and for clarity for companies to just have one structure. I think instead we're going to end up in a situation where law enforcement will send us something, and depending on the way our services are offered and our corporate structures, we will have different kinds of answers. And that's always more complicating, it's always more challenging, and it always slows things down. So it would be better to have one. I think that will quickly become quite visible as things kick off, and I would hope that would further spur movement towards one.
Yeah, that's how I feel. I'm looking at Vanessa. Shall we expect new Yahoo and Skype cases? Some dynamic judges, prosecutors who will try to use the instrument regardless of the law and trying to have it, and also sanction service providers who are not playing ball even if they have good justification.
Yeah.
That's
For sure.
That's the topic for the next CPDP.
Might be.
So let's see. We'll probably try to be there next year. Let's thank the speakers. Thank you very much for the attention.